uh, Dale and Melissa, y'all invite me to do a webinar this evening. I think that the invitation came from one or both of y'all saw my presentation at the statewide extension conference where I covered basically environmental law matters, just sort of a grab bag of stuff that went on in 2020. Some of which is still going on, some of which has been resolved, but it sort of still sits out there. And so, as such, it's probably a little too long to go tonight because I think what would probably be a lot more value to y'all is really type in some questions. I got two questions, coming in, one about business entities and one about mitigation bank maintenance. Um, and happy to talk about those. But please, type in some questions or just speak up and I'll either get to those. But this is not necessarily a talk on farm succession, though I can certainly talk about that and address any specific questions. What I'm showing y'all right now is kind of how I've gone about doing these online presentations. Um, this is the extension web portal that I manage out of the Department of Agriculture and Resource Economics. I just call it Farm Law, and I'm trying to get that title attached to it. Um, but I, I've organized it to really talk about a lot of the different topics that I work on in extension, farm succession, land use, agribusiness law, stuff like contracts and agritourism liability, things like that, and then some other topics, solar energy development, things like that. And so tonight, where I loaded in, and also if you are in a cooperative extension, I encourage y'all to link your county to this farm law page because it'll pull in. I try to get up something at least each week. So, um, but I think tonight we're in the land use topic, and um, what I do with the portal is I'll write up articles, stuff that's going on. If it's something that's kind of urgent, I might address it. And I'll put that in there. But I also post up my presentations, and so I'm still in the process. So it's always a working process of putting in information. But the presentations that I gave at the extension conference are generally these, and so I've opened them. I'll go and I'll talk about some of the these are some of the topics that I talked about, and and again, if you see something there that you're like, yeah, you really got to talk about that. Um, Note it in the chat box, and I'll make sure. But um, I could really just start from the top. But I spoke a little bit about the election. And what does that mean for farming? And there's actually an article that I would direct y'all to really dig into that topic from people that actually know, that actually work in Washington. Is a piece that I had written up about a panel discussion a couple of weeks back. Um, uh, where some this panel here hosted by the American Agricultural Law Association, talked about what we could expect in terms of immigration, state taxes, waters of the United States, and stuff like that. So I encourage all y'all to take a look at that, read that article. But in terms of of topics, we can just sort of moving through those. I think if um, we're part Duplin County, so let's talk. Let's jump to the resolution um, of the uh, of the swine nuisance cases, and because that was in terms of at least being resolved um, uh, in the um, in the Fourth Circuit Court of Appeals. Uh, the Fourth Circuit issued an opinion about that case, and I'll go through, with y'all what happened in it. Of course, this is concerning the 26 filed cases that were all filed in the Federal Eastern District Court in Raleigh back in 2018, I believe, 2017, 2018. Five of those reached verdicts of in the multi millions of dollars against Murphy Brown Smithfield, not against the farmer, the operator on contract, but against Murphy Brown as the integrator. And the issue there was, why didn't our right to farm law work? The reason that we passed that law in 1978 was to protect farm operations from neighbors being able to sue for nuisance, to say that your operation is invading my property right of quiet enjoyment, and you've got to stop. And so I'm going to ask the court to make you stop. Well, some lawyers took up these cases coming in from out of state, uh, and rounded up, 540 plaintiffs, and that may be a low number. I think that's the right number, but got five of these cases through to a verdict. The farms were shut down. I know at least in one case, and this is what the Fourth Circuit Court of Appeals noted, that one of the McIver farm, um, uh, it wa no, that McIver was the plaintiff. I'm trying to think of the farm name, but they had their contract canceled after the case. But the verdicts were reached, and the primary issue that went up to the Fourth Circuit Court of Appeals was our right to farm law should apply. It should stop these things in their tracks when they're filed, and more specifically, that the right to farm law, because it was amended by the legislature following these lawsuits being filed to make it harder to bring the cases. The changes were uh, the changes were you could only sue if you were within 1 mile of the lagoon or the hog operation, whatever was being complained of, not the border of the property, but the actual facility itself. Um, they had passed a cap on punitive damages, um, and there were a couple of other features that they had put in there. But suffice it to say that it was to make the filing the lawsuit harder for plaintiffs. And Murphy Brown, accompanied by Farm Bureau Federation, they argued to the Fourth Circuit Court of Appeal. So the verdicts are reached because it's a federal diversity case. It's based on state law, but because the plaintiffs are in state and Murphy Brown and Smithfield are both out of state, it can be heard in federal court. And so the case is appealed to the Fourth Circuit Court of Appeals in Richmond, and the um, the Fourth Circuit came back with the primary argument, saying that the right to farm law should apply retroactively and kick these cases out of court. And the Fourth Circuit Court, unfortunately, didn't agree with that argument, because uh, the new changes to the right to farm law were something different than what the law was before. The law before was about who could sue. Well, the changes related more to both to who could sue, but also who could sue for how much. And because that how much was added to it, at least this is my reading of the court's opinion, is that that's a different thing. It's not a clarification. So the verdict stood. Now the case was sent back to Raleigh to modify the punitive damages on a fairly arcane issue. It wasn't necessarily the cap from the law, but it had to do with the evidence of how much money Smithfield has. That was presented to the jury, and the Fourth Circuit said that was improper, that the jury could be swayed and making a big award based on that evidence. So, as soon as this opinion was issued, and this was beginning of November, I think, the Smithfield, Murphy Brown, and the plaintiff settled like the very next day, and so that sort of ended that. But here's why I'm bringing this up, and why I think the opinion itself, even though it's not precedent in North Carolina because it was a federal court, um, I think left us with something important, because the three judges, at least two of them, at least it was a 2-to-1 opinion. Two of them said that if these changes to the right to farm law had gone into place before this lawsuit was filed, that would have been a different story. If the statute that the General Assembly passed limiting punitive damages to a multiplier of loss in property value, which is going to be a very low amount. We're not talking about punitive damages now in the tens of millions of dollars. We're talking about punitive damages in the hundreds of thousands of dollars, if that. And so what the court was saying was, you know, if if the lawsuit was filed today, this statute would apply to limit those damages. And why this is important is I think it's going to make these just not attractive cases for plaintiffs' attorneys. The plaintiffs in this case work on cases like this, work on contingency mostly. The Texas lawyers that filed this lawsuit, they were going after a big money defendant, and so that ended up um, uh, they got their multi millions of dollars in verdicts, but moving forward, a law firm would not be as interested in getting several tens of thousands in fees because these are very expensive cases for lawyers to invest in. And the lawyers invest millions of dollars into these cases in the hope that that investment is going to get a return of several 100%. It's going to really be multiplied. Um, so that's where those cases shook out. And I guess what I'm saying is that my gut reaction is that a situation like what happened with these cases in Duplin, Sampson, and Bladen County may not come back, because the lawyers looking at the case might say, "Yeah, I don't think we'll make it to that many millions of dollars," because it looked like the Fourth Circuit, it looked like a court would look at the Fourth Circuit opinion and say, "Yep, the right to farm law is there for a reason and it works." So, and again, that's just my personal opinion on it. Now, the right to farm law was actually challenged. Itself was challenged by a group, and they filed that in Raleigh, in state court down in Raleigh. I don't know the status of the case though. It was filed pre-COVID, and then everything got put on hold. So um, I haven't been able to find out the disposition of it yet. But anyways, that's Murphy Brown. And anybody got any comments or questions on that particular topic? I can't really see the chat box. Oh, there we go. Um, sure. So, okay. So, anyways, that's the hog nuisance cases. Um, Other things that have gone on, recently, uh, from in 2020 and are still have somewhat been resolved. A big one that happened was the Ninth Circuit Court of Appeals in out in the Ninth Circuit in the western part of the state, uh, essentially decertified dicamba back in July. And what happened was a group of of various interests uh, sued the EPA over issuing a regulation allowing use of dicamba. And so the Ninth Circuit Court of Appeals felt that the EPA did not properly follow the Federal Insecticide, Fungicide, Rodenticide Act, FIFRA, and therefore they essentially they booted that case out, or they told EPA that you can't, this label that you have issued for dicamba can no longer apply. And yeah, I think it's in this one here. Sorry. And so what the EPA had to do following that decision was issue a ruling that said that that all use had to cease by, I think it was like July 30th. And I know that those of y'all working directly with farmers, were very much aware of that. The the EPA uh, came back in October, and this was under the previous administration. The EPA came back in October and issued a new rule that put out a new label for dicamba, and so now that's back in use. There's an issue going on right now with the local the state regulations, and I'm working on tracking the status of what those are. But it looks like dicamba is now out, under a new label for this season. And y'all forgive me, my presentation links are not they're not quite giving me what I want in terms of content. I'm very sorry about that. Uh, um, so uh, let's see. Um, Other big thing from 2000, well, starting not in 2000, but sometime back in 2006, is Waters of the United States. And so I'll give you all the update on that because that's something that there's debate on whether that's the Biden administration is going to change what the Trump administration changed from the Obama administration. And so this is a big issue in agriculture because it relates most directly to what a farm producer, landowner can discharge into waters of the United States. And one of the big contexts for that um, is wetlands. You know, what what really counts as a wetland, what falls under federal jurisdiction, and if a wetland falls under federal jurisdiction, then the landowner is required to get a Section 404 permit from the Wilmington District of the Army Corps of Engineers. And that it takes work to do that, to get one of those permits. They are issued, but they at the same time it's a administrative process that a landowner has to go through. And so the big issue is, well, how far up the river, so to speak, up the watershed, does the federal jurisdiction reach? And to try to explain it, I guess the graphic here is is this here where you have you know, we know this is waters of the United States. It's a navigable waterway. We've got areas here which abut that waterway there. But when you start getting in upland areas, the question becomes, is that area a wetland and what can you do with it? So the quick history of it is that this issue had been bouncing through the U.S. Supreme Court during the 80s up through the 1990s, all the way up to 2006, and a big case came out in 2006 called Rapanos v. U.S. And what a conservative majority of justices ruled, led by a now deceased Antonin Scalia, that unless your wetland, I don't know if you can see my cursor right there, unless your wetland abuts a tributary that finds its way to this body of water. The way I always thought of it and described it is that if you're standing at a wet area on your property and you can put a little rubber ducky in it, and that ducky could float on a surface connection all the way to the Neuse River or to, you know, the Cape Fear River or wherever, then you were waters of the United States. But if it was just connected by a drainage ditch, or if there was a berm in front of it, or there was something that it was dry most of the year, something like that, then it falls outside of federal jurisdiction. And unless the state takes over regulation, then the federal government's not gonna concern themselves with it. So after that administration, or after that ruling, the Obama administration, uh, basically on a technicality, was able to issue rules that were somewhat more expansive of federal jurisdiction. Not good for the farming community. This was fought in court by American Farm Bureau, and a lot of interests, lots of lawsuits were filed. Um, then we have a new administration in 2017, right? And this was first and foremost on President Trump's list, to undo that legacy and to essentially move the line of federal jurisdiction down the watershed, closer to where, you know, it's no question that water is federal water. And uh, his EPA and Army Corps of Engineers introduced the navigable water rules, and they finally got that passed in 2020. So is more of, I guess, a policy issue. The question now is, what will the Biden administration do? And um, my sense, and I was sort of getting this sense from that article that I was telling you about, what the experts actually were saying, is that this may not be one that the Biden administration spends a lot of political capital on. Certainly, his EPA and his Department of the Army can, on their own, under the Administrative Procedures Act, change the rule. But whether he's got there's other issues that are on the front burner. So I don't know if that's gonna be a very big deal. Um, uh, I on that note, this is probably a good segue into talking about the estate tax. Uh, that's coming back around. So, um, as y'all seen, tax presentations in the past, in the in the um, in the past several years, uh, that the exemptions that we enjoy under current tax law, which was passed in 1917, and I'm sorry, 2017, um, uh, significantly raised the individual estate and gift tax exemption up to 11.2 million, and that continues to increase up, incrementally, with inflation up through 2025. And at 2025, the law sunsets, and the exemption is going to revert back to $5.6 million per individual. Um, and so the question is, well, what will happen? Well, we know that will happen. That's, that based on current law, we know that families that owned a lot of land, that may be farming a lot of land and carrying a lot of equipment and owning enough land to get into to that danger zone, have to do some significant, planning, um, to um, to minimize their tax exposure, to minimize to avoid tax liability. It's not tax avoidance. It's just using the existing laws that we have in order to minimize a tax liability. So we know that that's going to happen to $5.6 million. Uh, Senator Bernie Sanders introduced a bill in the Senate at the end of last year, at the end of I think it was before the election, uh, further reducing that uh, um, to pre 2010 levels, and it would have been about 3.2 million or something like that. Now we're starting to talk about getting back down to where people are worrying a bit more. And so, the other thing I would, not to raise alarm bells, but the thing I would note is, I know that y'all have heard a lot recently in the news about the continuing resolution. What is that? The continuing resolution is the process of reconciliation between the budgets of the two houses, the two chambers, where they don't have to get that 2/3 majority vote in the Senate to pass major legislation. And so the reason I point this out is that the current estate tax exemption, estate and gift tax exemption right there, 11.2 million, was passed in 2017, not by 2/3 of the Senate, but in a continuing resolution. And so it only required a majority vote with, I think they didn't need Vice President Pence as a tiebreaker, but still. Um, and so, reason I bring that up is there's a lot of talk about the $1.9 trillion package that the Biden administration's proposed. There being resistance from that from an evenly divided Senate chamber, uh, to say that you won't get the Republican votes to vote that much money. And so there's a push to move that package through the continuing resolution process, and you would have Vice President Harris uh, cast the winning vote for the the relief package. They could do the very same thing. I'm not saying they're going to, but they could do the very same thing with the estate tax, because that's what the GOP did. They did the exact same thing back in 2017. So I'm bringing that up to say that, yeah, it's a thing. It's starting to come back. It's starting to occupy the minds of farmers and landowners, uh, that are in that danger zone. It won't go back to what I know many people remember as the $1 million exemption. I don't think anybody's proposing that happen. But it's a possibility that could go back, and so it is time to go back and see your tax planner, your attorney, to start addressing that situation, or at least start opening that conversation. And I always caution everybody to please also, though, and for a while, because we had these large exemptions, even 5.6 million per person, excuse me, that it's the estate tax has always sort of occupied the mind of the party that's planning, the farmer, the landowner, and not as much attention is paid to who gets the stuff. How do we structure this will? How do we structure this trust to make sure that the assets go to who and under with what circumstances to keep this farm operating, to keep the land and the ownership of the people that are going to manage it, or at least making it so that they can manage that land without being interrupted by some co-owner. So that's sort of my message these days on the estate taxes. Sure, it's coming, it might be coming, back into the danger area, but regardless, let's keep focusing on making sure that we have good trusts and good wills that put these assets where we want them to go. Because when I was in private practice, prior to coming to NC State, would see dozens of trusts that were prepared for the old law, and they did it. They did an effective job of minimizing the estate tax liability, but they did not address, who's going to get the farm equipment, who's going to get the land, all that, because attorneys aren't thinking about that, and I suspect the clients weren't as focused on that. They were just focused more on, I don't want the government to take um, to get this, and so, anyways, that's my pitch. It's I hope it's not too indelicate, but one thing I would also point out that to maybe relieve people a little bit, um, statistically, and um, this is going back again to USDA looking at this as pre 2017 law, is that even with that lower exemption, it wasn't killing so many farms as is supposed. The IRS statistics of returns that have farm assets, as you can see, this is nationwide. This is not North Carolina. So you had 230 farms nationwide that had to file a tax return, um, but they didn't pay a tax. And then you had 133 farms that did have a tax to pay, but we know nothing about what happened, how that tax was paid. Did the farm have to be, or farm land or equipment or anything have to be liquidated to do that? We don't know the answer to that. But the key thing also to remember um, is that you're only taxed on what you own when you die. I saw an argument recently by an advocacy group that said that estimated the size of the farm and equated that with the state tax liability. It's as all of you know, the farms that are being farmed are a combination of owned land and rented land. So we take that rented land out of the equation because that's not something that the taxpayer owns, and so I throw that out there because I saw that argument, and I thought it it was meant to alarm, and I think we can approach this issue better without alarm. But that said, and I'll move on to something else after this quick comment. We still have in the Internal Revenue Code tools, several tools that help apply specifically to farmers and to other business. But 2032A is specifically a farm and forest land um, feature that you can lop further value off of your assets and get a discount. There's strings attached. You got to keep farming it for 10 years, but like my the takeaway is there are still tools available. Folks just got to get in and be ready to structure things such that they'll be able to avoid a tax. Um, and and I guess on that note, here's my dicamba slide. Sorry. Um, uh, those are sort of the real big things that have been going on. The North Carolina legislature passed finally. It took a year to pass it because of smokable hemp. Um, but uh, um, the legislature passed a right to farm law, not the right to farm, the Farm Act of 2018, which did a number of things. And if I can find the presentation, I'll identify what those are. Uh, but I, I think that's the one. That's one of them that didn't come up. Um, but it did several things. It expanded the um, the bona fide farm zoning classification to allow catering to come off the farm, and if you're in the ETJ of a municipality that requires food licenses for doing catering, that you don't have to do that. Uh, there was a provision in there that if you have on your chain of title a very old right of way that say, Progress Energy or CP&L, I'm using those old names because that's from the time where it would have come from, never developed their easement, um, or something happened, that there's a process now by which um, you can file to have that easement removed from your land. Um, it was passed because that issue is affecting somebody. I don't know how many people it's affecting, but I can imagine that it's pretty much out there. And then another feature, which I think is also handy, uh, regarding present use value, the legislature passed a provision and added to that to the property tax law that if you become disqualified, if the county does an 8-year audit and finds that you don't qualify or you can't produce income records, you have to get notice from the county that you're being disqualified. It doesn't just show up on your tax bill um, in August or September. Uh, so I thought those are some pretty handy features that came up. And one more thing on bona fide farm zoning that the legislature passed was to add um, wildlife activities, hunting activities, things like that, to qualify as agritourism. So if you're running like a duck preserve or something like that, the legislature went so far as to add that language to say those are agritourism. So if you're having an operation that's doing those things, that's a bona fide farm. You're farming if you're doing that sort of thing. The legislature did stop short of saying that shooting ranges on their own are agritourism. They didn't go that far, but they did go. They did add some features to the definition of agritourism. The slide that I have up here right now, this is something that could may very well be an issue to swine and poultry producers. North Carolina passed um, what it's called the North Carolina Property Protection Act, and this was passed in 2017 or 2018, uh, and it's a kind of a pattern law that has been passed elsewhere, and they call them ag-gag laws. And what that means is it's basically a property protection um, for farm operators from PETA or ASPCA or somebody like that sending an employee into your operation with a hidden video camera to it's like, this is what goes on a North Carolina swine farm or poultry farm, and then your farm's footage shows up on in a policy briefing or national television or something. What this law was meant to create a private right of action on behalf of the farmer, that if your employee carried a camera into there and started taking pictures and took that footage out of there, the farmer could sue whoever it was that sent them in there, PETA, ASPCA, big pocket organizations. Well, UNC, the University of North Carolina, Chapel Hill, well, no, not sorry, it wasn't them. It was PETA, People for Ethical Treatment of Animals, sued the state, and in federal court, to declare that law unconstitutional on First Amendment grounds. And unfortunately, for the moment, the Middle District of Tennessee agreed, and said, I think this was back in it was in the fall, maybe very late fall, but said yes, or um, this is an unconstitutional law, and so they struck down key provisions of it. This has been appealed to the Fourth Circuit Court of Appeals by Farm Bureau, by the state of North Carolina. So we don't yet, I don't even think arguments have taken place in that case. So we won't know for some time what the result of that's going to be. A great question in the chat box. related to Murphy Brown Smithfield and Agag, I suppose. Uh, do voluntary agricultural districts help, keep down the threat of a nuisance suit? They are designed to. We don't know if they do, but they're designed to. After this, the after the Murphy Brown cases were filed, and the 2017 Farm Act. So North Carolina legislature now is has started to release these sort of grab bag laws that address a lot of little features and that concern farming and concern agriculture and forestry and land management, things like that. And we call them Farm Acts. And so those are starting to come out each year. Well, they come out mostly for the past 2 out of 3 years. And in the Farm Act uh, of 2017, following these cases being filed or being heard in federal court, um, the legislature switched one word in the voluntary ag district statute. For those of y'all who don't know, voluntary ag districts are a state law that we have where uh, any of the 100 counties, and 90 presently do, uh, pass an ordinance that allows farmers to enroll their land in a what we call a voluntary ag district. Essentially, what it does is it puts you on it puts your farm on the GIS map, and uh, um, and provides notice to landowners around you. And I'll show you an illustration of it here. This is Harnett counties. This won't be a very good. This won't be a. You can't really see the size of it there, but there we go. Essentially, what it's doing is that if you enroll your farm in a voluntary ag district, then the county GIS is going to apply a buffer around you, and it shows up on the map. So if I'm looking at buying some land here, then I'm on notice that I'm near a farm. As such, and this is the way I explain this, the way I explain this in my ARE 306 ag law class, that it reduces the likelihood, or it reduces the likelihood that a plaintiff will prevail in a nuisance action, because the thing that they're complaining about, the invasion of their property right, didn't exist. Their property right already didn't exist, or at least they had no expectation of it, because they knew before they purchased the property that their right to quiet enjoyment was somewhat diminished because this farm was nearby. Now, is the farm actually a nuisance? That's a jury question, but this is meant to try to take the air out of somebody, coming in and suing a farm by saying, look, there was a map that was in you should have researched that when you bought the property in your due diligence. So Jay, my answer is we don't know. We don't know because these haven't been tested in court. But again, it's theoretical. But the legislature felt strongly enough to now require all 100, or all counties who pass the VAD ordinance to put this map up. They have to do it. It's now that before they could, it was their option. Now they're required to do it. I don't know what the punishment is if they don't, but counties have responded. I spoke at a GIS conference a couple years back about this, and yeah, they were, all the GIS folks were there, uh, figuring out, how do we do this? But that's generally what it looks like um, when you um, when you do the voluntary ag district in your county now. So, I sort of feel like I'm bouncing around a pinball table a little bit. Uh, I've really sort of covered most of I think the issues that are important. There's some other things that I brought up. Um, uh, Solar update. Yeah, I think that's probably a good idea. Just to give you all an idea of where things are now in the realm of renewable energy. So, uh, you're down in Duplin County. You have a lot of open land. Y'all have probably experienced some in Craven County too. Experienced some, relatively large solar uh, PV facilities that have gone in. Um, Before 2017, there was a proliferation of solar development throughout eastern North Carolina. Why? Because before 2017, anybody with the capital, a solar developer, could come forward to a landowner, and as long as that landowner had road, right of way access, as long as they were uh, uh, had a three-phase power line running by or through their property that could connect, that where the facility could connect to the grid, and they agreed on the price, Duke was obligated under federal law to buy that energy, to buy, the a percent of that energy. So um, you had a lot of you had solar developers really going around and saying, okay, we're going to put this one here, we're going to put this one here, and um, Duke Energy lobbied the legislature, and it makes sense to me, the result. But the legislature passed House Bill 589, and what House Bill 589 did is it sort of put the brakes on things and said, "Look, um, we're going to change the process by which we do solar development in North Carolina now. Duke Energy is, and I'll kind of simplify it a little bit. Duke Energy will tell the Utilities Commission where it needs the power. Um, where it's going to be most efficient to site solar facilities closer to the customer base, develop larger ones that can be more easily managed, things like that. And so then the Utilities Commission puts out a request for proposal and said, look, here's what we're looking for in North Carolina for solar. And let's say we want something in, this area of Duplin County. Uh, well, um, then the solar developers go through the process of getting options with landowners and all of that, and they put it into this procurement system, so to speak, and then those proposals get reviewed, and then the right ones get approved. Well, there were supposed to be four tranches, tranche meaning a portion of a whole, um, coming out of House Bill 589. My understanding, a good friend of mine, she works with a lot of solar energy stuff over at a big firm in Raleigh. She said, yeah, it looks like they're gonna maybe get two of them done. What the thought was is this would shift development west of I-95. Not that there's more open flat land there, but it's closer to the customer base. So I haven't really been monitoring where these sites go in, but my my point is that when you're a landowner and you're dealing with the solar company, the issues are all still there. It's the same lease, it's the same issues, the same due diligence, all the things that go into it. It's just that whether or not you actually get approached is not as prevalent as it was before 2017. And so, whenever this question comes up to me, either from an agent or from a landowner, um, you know, I had clients when I was in private practice said, "Hey, we got some open land here. How do we get a solar facility in here? Because it's big money and it's mad money. It's I did a net present value uh, look at at a like a 30 to 40-year lease, and it's more than selling the land, particularly in a rural area. But but right now and I have some fact sheets that are going to be coming out here pretty soon um, on these issues, basically updating some work that was done back before 2017. And so those are going to be out soon. But that's sort of the lay of the land in terms of what's going on in solar. Um, I know I did talk about wind issues, but um, uh, um, that's not as really our only wind shed is up in the northeast corner of the state. That's where I took this picture here. What I will uh, update y'all though is that a subsequent bill that came out in I think 2017 or 2018, I think, House Bill 329 uh, required the DEQ to do a study on what happens to these solar facilities when we're done with them, when they run through their useful life. They're no longer producing enough energy to be viable. That's a lot of stuff. It's a lot of metal. It's a lot of silicone. So, what are we going to do with all of those solar panels? I always caution landowners, don't just go on the, we don't really need to worry about the money. Who's going to have the money to pull all this stuff out and restore your farmland back to the tillable state? Because you'll be able to sell this stuff. It's going to have great recycle value. And I'm like, no, no, we don't know that. We're talking about tech now against something that might exist 50 years from now, because that's generally how long these facilities, their lives are about 40 years or so with the renewals. Um, but suffice it to say, the DEQ just issued their study. I wrote a piece about it on the farm law site, and the reason I'm bringing this up is that issue of where does the money come from when the solar developer, whoever, or at that time in the future, whoever manages and owns the site, the equipment, do they have to come up with the money now so that when you sign the deal that there's going to be money later on to pull this stuff out? So you or your heirs, won't be stuck with having this big solar facility in the middle of your land and you can't get rid of it. The study stopped short of requiring that. It's not recommending that at this time. Counties have been pretty diligent, sorry, when they rezone for these facilities um, to require that there be a decommissioning plan on file. But again, the key issue is, will there be the several $1,000,000 available, in hand to actually do the work at that time? Because we're talking about decades from now, and the company, just may not have the money. Um, uh, Another great question. So I got an email today from one of my colleagues, Roger Van Hafen, about the CCC that a student had brought to him. And when I hear CCC, this is about carbon sequestration. This is going to be. I'm only just starting to get into it, so I don't have a ton to say about it. But it's what's coming down. It's what's coming down the pike now for farmers. Policy is being developed by the Biden administration uh, to start developing the programming by which farmers are going to be paid money to start adopting practices that's going to sequester carbon. Um, will it come in the form of direct payments? Will it come in the form of uh, uh, doing something with carbon credit markets to make them more accessible? I don't know exactly what it's going to look like. I don't. The proposals aren't really out yet in terms of what it would finally look like, um, but this is something that is going to be coming, and become available for farmers and landowners, uh, not in the not too distant future. Like I said, I don't know enough about it right at the moment to know exactly what it's going to look like, but it's going to be a combination of markets and direct payments, I'm pretty sure. The reason I brought up the CCC reference, one of my favorite New Deal programs was the Civilian Conservation Corps. Some of y'all may have had a grandparent, a grandfather that was in that in the 1930s prior to World War II. The new CCC that the Biden administration has proposed is the Civilian Climate Corps, and it's something very similar, but it's going to be focused more, I guess, on tree planting and doing infrastructure projects and things like that. So, but Jay, thanks for that question. That's right now what my take on the concert the carbon credits for farmers is going to be. One of the if I could put it this way, and I thought this was a great analogy. One of the lobbyists from DC that was on that panel that I referenced earlier, what they were saying, what their advice to the farming community was to everyone from American Farm Bureau, National Farmers Union, everyone is uh, up until now, or up until really very recently, the farming community in general has looked at climate change programs as a fastball that they're going to be hitting on their heels, which is very hard to make a good connection there. And you need to approach this issue on the balls of your feet and ready to hit it. And rather than talk about climate change and programs to reduce carbon output and things like that as a cost issue, that if the agriculture community comes forward and starts proposing it as a revenue issue and takes charge of that conversation, then that's where the real benefits are going to come. And I thought that was a very powerful statement that particular person made. Um, but I was shown a slide today by somebody um, that a coalition has formed with American Farm Bureau, with the Environmental Defense Fund, with the Nature Conservancy, a real, a group of odd bedfellows, but they're all focused around getting this money to farmers to sequester carbon. So, great questions. Thank you very much for throwing those out there. Um, but I think that's that at least in terms of the environmental uh, things that I had talked about earlier. That's the summary of what's been going on. Um, I think Melissa, you asked a question in the chat about fence law, and
So I can explain what the
yeah,
question is.
please.
Um, and it happened a few years ago, but out here on one of our main roads, somebody had some cows that were out and well, somebody had just bought, uh, I don't know, a new heifer, and it had gotten out in the road and hit somebody's vehicle.
Hmm.
So because we've got a main road that runs through Onslow and Duplin County that has quite a bit of farmland on it, this person said that they attempted to catch the heifer, but it obviously he couldn't. So, what are the defense laws in North Carolina in those situations? If
What a
he went,
wonderful question, because this is something that I've been dealing. I'll say I've been researching this quite a bit over the past 2 years, and it was brought about. For those of y'all here that are in cooperative extension, and everyone else, I want to pitch a program that I think is a great county level program, and it, what they called it or what extension called it over in Chatham County was barn to badge. And essentially what it is invite the highway patrol, invite the sheriff, the county sheriff, or some representatives to come in and talk about what they do when somebody calls and says the livestock's out, or when there's an accident, or even when there's a trespasser. I was part of a program down in Wayne County in November, and the Highway Patrol came in and basically went through all the hauling rules, which is a lot. It's a very detailed treatment of North Carolina state highway law, but it had a lot of new eye openers for me. And if I can just say real quick, did you know that if you drive your truck across a bridge that has a weight limit on it and the bridge collapse, you got to pay for that. So be careful. But anyways, fence law. Uh, our fence law in North Carolina is very, very basic. It's not like out west where you had the open range being a much later, um, fencing becoming as a later phenomenon later in the 19th and 20th centuries. North Carolina made the decision to be a not open range state back in the 1870s, leading pretty much up to the 1950s. And our basic fence law is that it's a misdemeanor, a class 3 misdemeanor, which is a low level, to not keep your livestock fenced. So there's nothing about the size of the fence, the height of the fence, anything specific about what a livestock owner has to do to comply with the law. The law just says that if you don't keep in your livestock, you don't keep them fenced, then that's a misdemeanor. But the question that Melissa's asking, which is the big question, is, well, what happens if someone gets hurt? That question is a jury question. That question all goes back to um, the evidence that the party who was hurt, the person came driving down the road and they ran into the heifer. Okay, let's say they're injured, and let's say that for some reason, the insurance company for the livestock owner doesn't settle the case. They're like, nope, prove it. Well, they go to court. Well, what the plaintiff has to bring to court is evidence that the livestock owner, this is something that's happened before. They might produce records from animal control, uh, that they might even subpoena records from cooperative extension on a farm visit for something like that. And my point is that the plaintiff has to come forward with evidence that the person who owns the animal acted unreasonably. And so if it was a history of this heifer getting out, um, if there was, if the it was just if the solar little solar power generator on the poly wire or electric fence had just not worked for a while, and the cow pushed over the fence, basically the farmer was being negligent. If the plaintiff can prove that, that's when they can hold the farmer liable for that type of injury. And there is a body of case law, and I wrote a research article on it that's slowly moving its way through extension fact sheet world. But that's that's a great question, and again, it's one that I got a call uh, from down y'all's way not too long ago about uh, uh, it was a heifer, it kept getting out, and the people next door just kept calling animal control over and over and over. And I told the farmer, I said, well, you really either gotta sell it or you got to really put it in a kennel almost, because now there's a record of that heifer getting out, and if somebody gets hurt, then that might be bad evidence against uh, your behavior. So but it's a topic, but I want to emphasize, I think it's a great it's a great program to get the highway patrol in to talk about hauling regulations. That's a lot of information there, because that's my biggest concern, worry. It was with clients, particularly out east, who are hauling a lot of equipment between farms, late into the afternoon, sometimes at night, all of that, and these things here, which drivers are looking at when they're driving down the road. That was always my biggest concern, and where the biggest liability was is when you're going from this outside of this gate, crossing the public right of way over to that to that field over there. So um, it's good to know
Hey,
what
Amber,
rules are.
we have a few more questions. I think Melissa actually emailed them to you earlier. Um, but the first one was benefits and or structures of LLC partnerships.
Sure. Um, I did pull up a presentation that I had done on that, and it's not quite complete because I've um, I've changed it somewhat. But the in terms of using business entities, and it's a great follow-up question to the discussion on livestock liability and fence law, because um, when you're sued, you're going to be sued for everything. You're going to be sued for everything that you own. Let's say that your insurance company has denied, uh, has said that what happened was outside of their policy, or that you're in default on the policy. You didn't pay your premium. Something happened, and you don't have the insurance company there to settle or try and maybe settle the case, or at least pay the verdict. Well, in that, it's again, it's somewhat of an extreme case, but in that case, the plaintiff is coming after whatever you own, your land primarily. And so it makes sense to take your business assets, your livestock, your equipment, everything that you're using as a as a business, and go ahead and put that in its own little bucket, and we'll call that bucket a business entity. Um, the most prevalent business entity, well, and so what that does is that if there's a judgment against you, it's going to be limited to that bucket, and your savings, your land, your personal assets are all going to be outside of that bucket, and um, the plaintiff can only recover from what's in this particular bucket. Um, that's the primary liability purpose of of an entity. In this day and age, in 2021, the entity of choice is really the limited liability company, and that because it's just it's more modern. The the entity that used to cover this, the two entities that used to cover this liability limitation feature were the corporation and the limited partnership. Uh, Both have sort of fallen out of favor. They still exist. I know plenty of people that still have their land in limited partnerships, and even some people that have in corporations. But the LLC came along to basically merge the partnership organization and the corporate liability limitation organization together. So you have this new entity called a limited liability company that's very easy to manage, or a lot easier than a corporation, and it provides you a liability limitation, unlike the partnership. So in terms of bringing up, partnership, I really don't know any farmers that use that entity when farming with someone else outside of a specific situation, which I'll bring up in a second. Um, but my biggest use of business entities in the farming context was in farm succession, because as the family grows and matures, the farming operation grows and matures, and let's say a son or daughter has come back to the operation. My as a lawyer, my if the goal of the family was to keep this farm and this farmland in operation, I'm wanting to put in mechanisms that are basically going to make it difficult for anyone in the family to start pulling things out. And so I would put assets in an LLC, and then that's how the farm is transferred. Interest in the LLC is transferred rather than we wait until someone dies and then we see who inherits it through their will, or if they don't have a will, then through the Intestate Succession Act. And so, to me, the big benefit of a business entity, an LLC, is that it it basically creates a closed marketplace, to where there are stopgaps in place, options in place to make sure that when things happen, like someone dies or someone becomes disabled, or one of the owners goes through a divorce, or just walks away, uh, how how do we make sure that those assets stay? If somebody wants, unless everyone decides to sell it all and go away, if someone wants to keep going, it provides a mechanism by which they can hold on to those assets and not have them liquidated. And my use of LLCs in law practice, um, the first thing I would say is that in forming an LLC, and people say, well, when's the right time to do it? Well, when you're real young farmer in your 20s and you're renting some land and all that, and it's sure it's fine, but really when you start having employees, uh, particularly when you're in a place where you're farming more than one field and you're taking your equipment out on the road, that's that's where I start to see the liability dangers increase. And so, my suggestion is take your operation, form a limited liability company, and then lease your land. Uh, at that, have you as the landowner own the land, and you're renting your land. You're not now farming it yourself. You're leasing your land to the entity, which you may own, and you may be the only member operator of that entity. But at the same time, it's creating somewhat of an arm's length transaction, which does become much more effective when you have other owners, when you have another owner in the LLC, uh, and uh, that or when an employee has made a decision that's caused an accident or something like that, it can be an effective liability limitation. Now, I use LLCs a lot for families that own a lot of land, because it's also an effective transfer device for uh, for gifting interests in property to reduce the taxable estate. Going back to the estate tax, reducing the taxable estate of the parent generation, and that's something that I used quite frequently. And I don't know if y'all recall, but back in the estate planning discussion, I had a bullet point there about valuation discounts, about bringing the value down on that million-acre piece of land down to maybe $800,000 or $600,000. You can accomplish that if you do it the right way by using a land LLC, because you've now restricted the ownership of parcel and it's not as marketable on the open marketplace because you have this LLC, which limits the number of buyers out there for the interests. Um, and so the operating agreement, this is the key contract. I always remind everybody that an LLC is just simply a contract between the owners of assets. Um, and but it covers a lot of things. It covers, who can be a member. Can I can be a member? Can my son or daughter be a member? Can my spouse be a member? And so you can restrict membership that way. It lays out, how decisions are made. Can certain people make decisions without having to get a vote? That's very common. But if you're going to sell land or buy another piece of land in the entity, take out a loan using the land as collateral. You can say, what the vote has to be for that sort of thing. But the big thing is in there is the option to purchase, the buy sell agreement. To me, that's the nuclear core of these, and what really operates to make sure that you're dealing with a closed market, an internal marketplace for these assets, rather than them sort of swinging out or spinning out and getting to members of that you don't want, people that you don't want to have them, like ex-spouses, uh, kids with drug problems, whatever it happens to be. So, but they're it's I strongly recommend that if you are, operating a farm, and particularly if you're looking at farm succession, that you consider, how to use an LLC to transfer the interests. Here I have a slide on, it's a little bit old, but uh, I'm in Drive, so I can just change that right there. Um, that it's very easy to gift interests of an LLC and not have to file a gift tax return in doing so. There's a process. I will have it outlined. I've got a piece that I'm working on, also that goes through and explains how to do this. Um, in terms of resources about business entities, if I can, again, a little bit of, self-advertising, but going back to the website here, and is where I generally cover a lot of these issues. I have a narrative here on forms of business. Here's a piece here on, how do you form an LLC? What are the steps? What are the decisions that you have to make before you, pay that filing fee to the Secretary of State and file it. And I also have uh, some narratives that talk about these options to purchase um, that exist inside operating agreements. How do you evaluate the interest in the company to um, when there's going to be a buyout situation? So I encourage y'all to, to look through those. They're pretty short. And then this is really a general one just on the difference between sole proprietorship, partnership, LLC, corporation, all of that. So
Andrew, Andrew,
yes.
excuse for the sake of time, because this Zoom's only limited to a certain amount of time and it's gonna kick us off shortly.
Oh no.
Um, yeah, that's the way they work sometimes. So does anybody have any additional questions they would like to ask at this time before we have to end this, or it ends itself because we run out of time?
Um, yeah, I always have to fill in silence. Somebody did ask a
I said
question about. Go ahead.
Melissa put in the chat box the farm law extension NC State link site, so you can access in that chat box and copy it.
It's a work in progress, but please explore it. The one last question that someone had, they asked a question about stream bank maintenance after the maintenance agreement has expired. Um, that's a great question. I've been within that sort of situation before, but it is still unresolved. I think my most direct answer to, or trying to address that question, is what does it say in the contract agreement? Um, uh, and that's, I don't know if there's a regulation that exists that's going to require ongoing maintenance, but I've seen that before. And I think what the issue was is that it's just not being enforced by the regulators. I'm thinking, recalling back to the project I was dealing with that on. But I would encourage you, and all of you, if you would, here's my um, here's my email address. So, what I do for cooperative extension is, yeah, I write, I give presentations. I can't wait till we can give presentations again out in the counties. But I address questions. People send me emails all the time about all sorts of stuff. And why it's good is because I give you some information, but I'm learning about some things that are going on out there that I might not have been thinking about. That stream mitigation bank question was one that rings a bell, but yeah, I need to look into that. Um, so my email address, not very intuitive, RABRNA2 at ncsu.edu. Yeah, that's it. So I just say I like hearing from people, and encourage y'all to, if you've got a question on your mind, to go ahead and ask.
Okay, I guess everybody's asked all their questions, or they can email you directly if they have any to think of later on. With that, thank you so much, Andrew, for joining us tonight in this series. This was the last part. As just a quick announcement, on March 1st, we're doing our area grains meeting, our winter meeting. It'll be virtual like all the rest of the meetings have been taking place so far this year. It's Onslow, Duplin, and Sampson and Pender counties. So if you have not seen an announcement about that yet, about how to sign up for that meeting, please contact your local county agent for that information. So with that, I guess we're finished up for tonight.
Well, I appreciate everybody coming. And again, I hope this was, somewhat helpful, but I think really you can see it's a lot of, law is a big topic. And so I probably do better one-on-one. So send me an email. But yeah, I appreciate y'all tuning in, and Melissa and Delia invite me to do this. So I appreciate it.